When you think about Cherry Hill, the sight of highways and shopping malls comes to mind. Most of the community is developed. This quiet parcel of wetlands was set aside in 1994. This preservation story is the result of a lawsuit by two local citizens, Bob and Roxanne SHINN.
It may not be high quality, but in Cherry Hill it's high quality because there's so few wetlands left here. This town is over 70% developed.
In Cherry Hill, this is one place where, if you can believe it, it's more quiet than any place else in the suburban community where there are people and cars and the noise of traffic is not so disturbing.
It all started in 1993 when a 1.7-acre section of wetlands in a different part of the township was filled by the New Jersey Department of Transportation as part of a roadway project. The agency hadn't received the proper permits to do the work. To compensate for the loss, the state DEP said the Transportation Department would have to set aside twice the amount of land that was lost, but it didn't have to be in the Cherry Hill area.
Now, we didn't think that was right, and we thought that it ought to be A, within the watershed, and B, that it ought to be a lot more land. In other words, they ought not to get off scot-free for having filled this wetland without a permit.
The SHINN sued the New Jersey Transportation Department and the Federal Highway Administration under the National Environmental Policy Act and the Clean Water Act. The couple was trying to get the agencies to conduct an environmental impact statement on the Route 70 widening project and to stop filling wetlands, rivers, lakes, and streams.
There's a provision under the Clean Water Act called the citizens' suit provision that allows private individuals to act as if they were the state, acting on behalf of the state. You have to file notice with the state that you're doing this. The state can then do the right thing, or if it doesn't do anything, then after proper notice, you're allowed to pursue that course of action in federal court.
Eventually, a settlement was reached.
And as part of that settlement, they agreed to our requirement that a conservation easement be placed on these 30 acres, which is a legal term that means it restricts the types of uses to which the land can be put. In this case, the easement said that the land would be preserved in its natural state in perpetuity.
The Department of Transportation also agreed not to widen Route 70 over a 10-year period. This case is a good example of how citizens can independently take action to protect water resources under federal law.
It's an arduous process, but it is an important remedy available to citizens as a last resort if the government's not doing the right thing.
Every individual has the ability to protect some of these resources.
But this option for concerned citizens who are trying to protect waterways is being threatened. A bill in Congress would require parties bringing a lawsuit to pay attorney and expert witness costs if they lose the case. This project was funded in part with a Franklin Parker Conservation Excellence Grant given by the New Jersey Conservation Foundation.